Good afternoon to you all. My name is Nkanyiso Kumete. I'm a researcher at PLUS. Today, we are looking at the Traditional Courts Bill. We are looking at whether, if it is passed into law, it will ensure access to justice for people in the former homelands and whether it is necessary. The first version of the bill was introduced in 2003, and 18 years later, there are still contentions on its contents. Today, we will have the opportunity to look at the history of the bill and its intended aims. We'll also look at the current version of the bill and explore what is at the heart of the contestation. We'll then get a reflection on the potential impact of the bill and look at what should happen moving forward. After that, we will then go to you, the audience, for questions and comments. For those of you on Twitter, our hashtag is Traditional Courts Bill. For this webinar, I am joined by two guests. The first one is Nolundi Luwaya, who is the Director at LAC at the University of Cape Town. The second speaker is Connie Mogale, who's the National Coordinator of the Alliance for Rural Democracy. Later on, we are going to be joined by our third guest, which is May Molomo from a village in Limpopo. Welcome to you all, my guests. So what I will do now, I will start with you, Nolundi. Can you please take us through the history of the bill and why it was developed, and then take us through the contents of the current version of the bill? Over to you, Nolundi.
Thanks, Nganyiso, and thank you for the opportunity to be part of this webinar. As you've pointed out, the Traditional Courts Bill came about in 2003 when the South African Law Reform Commission created a draft version of the bill. That version of the bill was not well received and was rejected. And in 2008, we saw a version emerging from the Department of Justice that was quite a problematic version of the Traditional Courts Bill. It centralized power in the role of the traditional ruler and made it an offense for people to opt out of the traditional court. We then, there were objections launched against that 2008 version, particularly from women's groups who felt that the bill did not offer them adequate protection. And in 2012, the same version of the bill was reintroduced into Parliament. And in that process, we saw a very, very active participation from rural communities, which I think Connie will speak about. And rural communities really making it clear that this was not the bill that they need, nor was it the bill that they felt aligns with customary law and how traditional courts operate in practice. And so in 2014, the bill lapsed. And in the years between, the Department of Justice instituted a process of a reference group that involved members from civil society organizations, traditional leaders, and other stakeholders. And from that reference group process emerged a bill that we saw in 2017, which was a much better version of the Traditional Courts Bill. It was a version that indicated the processes of compromise that the reference group had worked so hard for. And it was a version that provided an opportunity for people to opt out of the bill and provided a process for that to be exercised. It also gave much better protections and recognition to the experiences of women. And it also was a version of the bill that really acknowledged the voluntary and consensual nature of customary law. That 2017 version then went back to the Portfolio Committee in the National Assembly. And over the years of 2017 and 2018, the Portfolio Committee made some very drastic amendments to that version of the bill. And under the then chair of the Portfolio Committee, Dr. Matole Motshekga, the bill was altered quite significantly. And a lot of the compromises and useful advances that the reference group had developed were actually removed. And so the bill was amended, and it does not any longer allow for opting out, and those provisions were removed. But so were the provisions that acknowledged the consensual and participatory and voluntary nature of customary law. And so it's that version that has now returned to the National Council of Provinces and has now gone back to the National Assembly after the National Council of Provinces made some minor amendments. And so the National Assembly's Portfolio Committee is looking at that version of the bill and working towards finalizing that process. So that's kind of the long history of the bill. To speak very briefly then about the content of this version, as I've pointed out, it no longer provides for an opportunity for people to opt out. And this was something that rural communities were very clear was a necessary inclusion in the bill. The feeling was very much that people must be able to exercise an ability to choose whether or not they want to use these courts, as opposed to being required and coerced into using these courts. And really, that also aligns with the voluntary nature of customary law and the idea that it's a system that people choose to opt into, and that's where it gets its legitimacy. In addition, this version of the bill lays out various sanctions and decisions that the traditional courts can take. And so they can deal with matters related to theft as long as it doesn't pass the 15,000 Rand threshold. They can deal with matters related to damage to property, assault that doesn't constitute grievous bodily harm, criminal injuria, and then they can provide advice on a range of customary law practices, including ukutwala, customary marriage, initiation, as well as something that's termed customary law benefits. And then there's a catch-all, which is basically that the courts can also deal with any other dispute that arises between community members. So really the kind of concern around the content of the bill currently is that it is significantly narrowed from that 2017 version, and the worry is that it doesn't fully align with customary law as it operates in communities.
Thank you very much, Nolundi, for that history that you've just shared with us, and also reflecting on the contents of the current bill. Because I think it's very important for us to understand that what are the issues with regards to the bill, so that people are able to make up their minds with regards to whether the bill will ensure justice or not for the people that are living in the former homelands. Yes. Now I will move to Connie. Connie, Nolan has taken us through the history and the contents of the new version of the bill. And on another side, you work with communities that will be affected by this bill if it is passed into law. What I would like to know from you, what has been the responses of the communities towards the bill? Do they feel it will strengthen their position in terms of accessing justice? Do they think it's necessary? And then once you've reflected on that, I'd also like you to reflect on whether the communities were properly consulted in the development of this bill. Thank you. Over to you.
Thank you, Nkanyiso. And thank you, Nolundi, for taking us through the new version of the bill. So, yes, I was part of the reference group that was representing civil society together with Mam Sizani, the late Mam Sizani Ngubani of the Rural Women's Movement, Sis Nomboniso Gaza, who's an advocate of customary law, and Tusi Rapo, who's a member of a community of Bafokeng Royal community in Rustenburg, and Afra in Pietermaritzburg. So we were four representative of the civil society at the reference group, and we were with traditional leaders who were outnumbering us, and the Department of Justice officials, and sometimes COGTA will visit. And yes, like Nolundi have already said, there was a compromise, which was a better version from the later version that was run down by 5 provinces in 2012. And from the first introduction of this bill, this the communities, the rural women, the civil society has really was not happy about and objected to the version of the bills, which is going to apply to the former homeland, which is a home to 17 million people of South Africa. And this version of the bill, the new one, we thought it's a compromise. It was launched, even though we were not even happy because we didn't see the final version which went to parliament. But we said, okay, because it provided, so the minutes of that meeting was providing the consensual aspects of the bill that we agreed with and those that we didn't agree with. And it is not explicit in the representation of women in the council. Like it, if you are summoned as a woman, it is not it doesn't say women can represent themselves. It's not clear on that. It counts on the mayor, so we have to depend on the mercy of that council or the traditional leader to have this consciousness around the rights of women and around the right of women to represent themselves. And we know that customarily there's a bad practice of undermining women. Many women still can't have access to land on their own right. They have to have their married male person or the son to access land. And many household, intra-household challenges and struggles around gender are still not resolved. So we are not going to count on the mercy of the institution. It should be explicitly written in the bill. And then the other thing is that when John Jeffrey was representing this bill for the first time in Parliament, when he told them that the bill is not going to be constitutional because of the opt-out clause. Now, without that opt-out clause, there is no balance in terms of the structural power relations that exist in our societies. And without opt-out and without a legal representation, which is the right in our constitutional, then there's no balance. We are just thrown into the pit. So our most fears is that the land issue, because we know that if the traditional leader can summon you to court and you have no right to opt out, they can easily say, okay, you didn't apply, so we are not gonna we are gonna take your land rights away. We have many stories of women in KwaZulu-Natal who are telling us that the land was just taken from them when they are just at the production level, when they are supposed to, when they use the land in their own projects. We've got so many traditional leaders, female traditional leaders who are just bullied by the other traditional leader next door for the mere fact that they are women. We've got so many bad practices, and that is why we're not gonna just depend on the mercy of an institution without a law. Now, your question around whether this is necessary. We know the history of traditional leadership. We know the disputes that was lodged with the Nhlapo Commission, which were unresolved. Right now, there's a petition going around the Northwest people demanding that the Maferica Commission must be released. And we don't know what is the reason for the Premier and the government of the Northwest not to release that Maferica Commission report. So we know that there's so many things, there's so many disputes. Now, we didn't vote for this in 1994. We because of these disputes and this contradiction of this institution, we voted for the alternative vision of democracy in South Africa. And as rural people, we feel like we are being discriminated, we are being treated as subject of some men or some sovereign governance which are not belonging to South Africa, because in South Africa we've got the constitution of the country which guarantees equality, which freedom of movement, and we cannot now be locked in a system of traditional governance which we are not affiliating or voluntarily affiliating ourselves to. We know that communities were built on top of communities, and land issue is involved in there. Therefore, traditional leadership must be consensual. You must affiliate voluntarily. You must feel like, and it doesn't have, in fact, customary law doesn't have borders. So this is the fact that Sis Nomboniso have been trying to You can stay in Cape Town. If you affiliate yourself to a certain community and traditional institutional laws, it is a social contract that you make, that this is me, I'm Motswana, I'm from Batong, and therefore I'll go by the rules. It doesn't matter where you live in terms of boundaries. But now, if you are going to be locked into a system of governance where you don't feel like you will be treated with justice, it is so unfair. Imagine, one thing that was good about doing this bill was to bring access to justice next to the people. Now, if you're going to bring access to justice next to the people, yet you don't have the appeals mechanism, still say you must go to the higher level of traditional institute, how near is justice then? Then it's not happening. So the civil society, and not I don't want to say the civil society, because civil society is not homogeneous, but the communities which are going to be affected by this bill are saying no. If the representation of women is not explicit in the bill, we are saying no to the bill. If the issue of land and the kind of sanctions that can be done by this court is not clear, then we are saying no. We cannot be subjected to a traditional leader. There's so many contradictions. There's so many power imbalances. Imagine you are complaining about the traditional leader. Maybe you have a dispute against the same traditional leader. Because look at Sekara community, Moletele community. The traditional leader just decided to lock the people out of their fields. And now where do you complain? If now, because you are in this jurisdiction, you must face the same perpetrator to complain about your land rights issue. And when we know that land rights and land issues is a national issue. So there's so many things about this bill, and we are saying we cannot afford about that. We have tried, we have launched the Stop the Bantustan bills to say to the president, listen to us, listen to our version of the story. And we have, as the Alliance for Rural Democracy, we sent them 7 bottom lines. One of them was that consultation, if there's going to be a traditional courts bill of any kind, it must start from the villages. So if we can ask for like the regulatory impact assessment to say, what are we trying to address here? What is the problem we are trying to address? The Department of Justice is not giving us anything. Therefore, we are not able to say yes to this bill. Thank you.
Okay, thank you very much, Connie, for that reflection. Maybe before I go back to Nolundi, I want just to understand something from you. The communities, when they oppose to this current version of the bill, is this opposition to the entire institution of traditional leadership or the traditional courts, or it's just an opposition to the bill?
So it's an opposition to the bill, because this bill is a national bill. It is not context specific. So I'm not going to be able to say it is the overall consensus to the institution of traditional leaders, because we as the civil society have never said, we don't even have that right to say we don't want the traditional traditional leadership institution. It is there in the Constitution of South Africa. So, but we are saying contexts are differing. Whatever people are experiencing in the villages of KwaZulu-Natal, we cannot wrap the whole country with one thing. And that is why we are saying it must be context specific. And if it's going to be a national bill, even those good ones who treated people okay, but because this is a law now, that is what we are opposing, that it cannot be a law which is a one size fits all. It must be adjusted as according to context. Thank you.
Okay, no, thank you very much. Nolundi, Connie earlier on touched on the issue of the Stop Bantustan bills. And I know that your organization has been part of that campaign. We saw demonstrations, we saw memoranda being submitted, letters being written to the president to protest the Bantustan bills. But we still see them being pushed. And in 2019, late 2019, one of them was actually signed into law, which is the Traditional and Consent Leadership Act. Now we have this bill. What I would like to ask from you, why is this happening? Are politics at play? What's going on?
So, Nganyi, so I think there's a lot going on, and I think part of it is political, but I think there is also this question of mineral resources. And so many of the communities that will be impacted by laws like the Traditional Courts Bill and the Traditional and Khoisan Leadership Bill are also the same communities that live on land that is very minerally rich. And so, what is a kind of an interesting connection to observe and an interesting underlying reality to see playing out is the fact that people who live on the land that has this mineral wealth beneath it are communities that have held these land rights for generations under systems of customary law. And what you see happening is that communities are being dispossessed effectively. They're not being given adequate compensation when they have to be relocated. And you're seeing that communities are not actually benefiting directly from the wealth that comes from their land. And so what these laws set up is they facilitate through law the further kind of advancement of these processes of dispossession. And the way that they do that is that they all centralize a lot of the power, the decision making, the authority to enter into agreements with mining companies and other development forums on behalf of the community. They centralize that kind of power into the person of the traditional leader and into the traditional council. And I think that, as Connie's point about the fact that we cannot have laws that are one size fits all and that don't offer basic protection, because we have to acknowledge that for some communities, their traditional leaders don't act in ways that are about advancing their interests or protecting their rights. And there are, many examples, the Bakhatla Bakhafela, the Bapo, where you've seen immense mineral wealth just vanishing, disappearing into the pockets of a rising elite, while communities remain without information as to where all of that money has gone, and with very little understanding as to who signed the contracts, who took the decisions, who is the person who authorized the advancement of these mining projects and other forms of development. So really, I think that there is both a political and economic interest here, and it is playing out in a way that really disregards the land rights of customary communities and communities that live under systems of customary tenure, but it's also being facilitated and made possible by this network of laws that is absolutely determined to adopt a model and an understanding and an approach to customary law that is absolutely geared around the role of the traditional leader as the central authority, as the person who can make the decisions about people's land rights. And in that process, you're undermining the agency of communities, but you're also undermining the fact that they are land rights holders. And these are decisions that must be theirs to take. So I certainly would say that I think there's both a political and economic element at play here. And that's what's influencing the context within which these laws are being passed.
Okay, no, thank you very much, Nolundi. Connie, do you have any views with regards to maybe what you think is going on with regards to these bills that we're seeing being pushed? You are muted.
Oh. Hello. So I thought Sis Margaret from the village of Mapila was gonna come in, and that's why I wanted to cut, because every time we the voices that appears is us, and then it's a very it's problematic that we are not unmuting the rural voices, but I mean it's a political problem as well. So at the heart of this bill is mineral wealth. So why we said stop the Bantustan bills is because it's a matrix of bills. It's not one. So if you look at the Traditional Leadership and Quiescent Bill, Section 23 of it, and you look at they wanted to amend the Communal Property Association Act, which gives people an alternative governance system if they are not happy, but they want to govern their land as a group. They also wanted to amend the Mining and Petroleum Development Act to erode this principle of consultation and consent. And now the civil society, we have a campaign of the right to say no, because of people have to be consulted about any development that is coming to their area, and that act has Section 54, which guides the processes of consultation and consent, and what should happen, what should be in place before any development comes in. So before any mining comes to operation, agreements with the land rights holder and the mining rights holder must be in place. We need to know. So they also pull in different departments inside there. The police, they've got a role to play. The Department of Cooperative and Traditional Affairs, Cooperative Governance and Traditional Affairs, the Department of Rural Development is a fence sitter, and we don't know why, because they are the custodian of communal rights. They are a fence sitter, and now they want to come up with the Communal Land Rights Act, which is going to give powers of outer boundaries to the traditional leader and give tenure security to people limited to their own residential areas, about what's happening about common property where people grazing and the rivers and everything. It's gonna be the traditional leader. So if you look at all these bills, you will see that they are strategically, and the culprit is the Department of Justice, the Rural Development, the Department of Cooperative, and even the local government, because you don't understand. So there is one thing. One thing is to make sure that traditional leadership has powers over land, and they can take decisions without consulting and getting consent from the people. And they can now, if you have if you argue your rights as according to the Interim Protection of Land Rights Act, they can now summon you to this court and make you feel like you are guilty of something, and then they can make decisions about the land. So this is why we are saying this is the Bantustan bills, because if they were laws that are going to be applicable to South Africa and to uplift the citizens of South Africa, why does it have to apply to the former Bantustans only? And why does it have to give traditional leaders power over land? And when the Minister of Land Affairs is the one who's supposed to be a custodian of land up until chosen by the people. So that
I don't know if we've lost Connie. Connie, are you still here?
still.
Oh, okay. No, thank you very much, Connie. Just to clarify to our viewers, we had invited Memulomo, but unfortunately she's unable to join us because of connection problems. Nolundi, before I go to our questions, could you kindly explain to us briefly the issue of the opt-out clause that both of you have been reflecting on? What does it mean? Maybe if you can just frame it with regards to the laws that we have here in South Africa, the justice system that we have in South Africa. What does it mean, and why is it important? Thanks.
Sure. So the opt-out clause is effectively an ability and an opportunity for people to express a choice, right? And so I think we all recognize that customary courts and traditional courts in these communities offer an alternative avenue to access justice. And nobody is disputing that. But part of the legitimacy of a customary law system is that people have the ability to affiliate. So as Connie was saying, people have the ability to say, I am, a member of this community. I think that traditional leader so and so is somebody who, I respect and someone that I am comfortable sort of acknowledging and recognizing as my traditional leader. And so that same principle, that principle of a voluntary choice to affiliate, a voluntary decision to be part of the system, to abide by the rules, the practices, is an inherent part of customary law. And so when we speak about the opt-out, opt-in clause, we're talking about making sure that built into the law is the ability for people to make a choice, to say, actually, I don't feel that if I take this matter to a traditional court, I will be able to get a fair hearing, or, actually this matter has to do with the conduct of the traditional council, and I don't feel that I will receive a fair hearing. And people then have the option to opt out, to not use that as an avenue for accessing justice and an avenue to take their matters. And for women in particular, the ability to exercise this choice is critical, because as Connie has indicated, the experiences that rural women have of some of these forums is a place of, highly oppressive exclusion, and the inability to voice their concerns. So when we're speaking about this opting out, opting in, we're talking about choice. We're talking about the fact that the Constitution enshrines the right for people to live the cultural life of their choosing. And so an opt-in clause, a process by which people can exercise this choice, would, in our opinion, be in line with that constitutional value.
Okay, thank you very much, Nolundi, for that. Now we will go to our first question or a comment from Tembi. Tembi Chabalala, she comments, the bill in the current form. Okay, I think it's a question. Yes, it's a question. Does it violate the rights of rural women? I will ask Connie to respond first, and then Nolundi will come in second. Thank you.
So last week, I think 2 weeks back or last week, we were in Limpopo having our own mobilization meeting that we hold as the national, as the rural, the Alliance for Rural Democracy. And we had a women's group only. It was like a joke. So this woman was giving us her experiences around. There's an echo, I don't know where it's coming from. So this woman was giving us her experiences around the traditional courts in her village. And that's what I wanted Margaret Mulumu to come and speak about. So apparently women are not allowed to represent their cases. They need a male person who is not a lawyer, who's like maybe a family person to represent them. And what she was telling us is saying, in a case where there's no males, like in your family, women can address the court, but they have to face that way. So they must give the court. They mustn't face the traditional authority, the council. They must like never share an eye contact. They must look at the back. So I asked her, when did this happen? He said, like in December 2020. And I was saying, are you for real? So it is not me. I'm not living in the traditional authority. I'm working in Joburg, and I'm not going there every day. So it is we cannot make noise about something that is not going to apply to us. It is the women's experiences that are telling us what's happening. So if you go to KwaZulu-Natal, there's this mama called Mam Gati who are telling us the way in this mama is a strong activist who really stand up and fights for her rights. And if he tells you how many offices of COGTA did he knock in the rural development trying to assert her rights against the traditional leader, the institution, you ask yourself, what about those submissive women who find themselves in an environment which is hostile, where they have already accepted their fate, that it is because they are women? What about them? If a woman like this can go to all avenues and still cannot, be recognized in her own rights, a mama of over 80 years. So It is not us, Tembi, it is the women there who are telling us their experiences. And even if I'm not living in the rural areas, I'm telling you that this is what is happening in my family. I I hope they are listening to me because that's true. I can be an assertive Constance Mohale, but I had an experience at the funeral of my father, at any gathering that's happening at home. Men are supposed to take decisions. If they are not saying this should happen, it will not happen. So we know that it is happening even in our houses, this thing of women being oppressed. So we cannot have it as a law. Our constitution guarantees our rights. We have all these international laws like the Convention on Elimination of Discrimination of Women that our country is a signatory to, the Beijing Platform of Action. And let's leave that because we are international. The consensual nature of customary law. We cannot have laws today that want to erode all of those rights for women to, to take a stand and say what is justice for them. So this is what's happening. It is not maybe I shouldn't have said it is rural women who said that. We experience it every day in our daily lives.
Okay, thank you very much, Connie. Now we'll go to our next question, which is from Malin. Behind pushing for the regressive changes to the bill, and how were these able to win over the more progressive interpretation of custom expressed in the earlier version of the bill? I think Nolundi will reflect on that, and then Connie will also reflect because she was part of the reference group that was part of the formulation of the other bills. Yeah, thank you.
Thanks, and thanks to Marlon for the question. So the key thing here, Marlon, is I think that when it comes to these laws relating to customary law and customary rights, we're seeing a real shortcoming in Parliament's role. There is clearly a shortcoming in the legislative process because it was in Parliament, it was the Portfolio Committee under the guidance of the former chairperson, Dr. Matole Mochega, that made the changes that were so regressive. And the types of arguments that were being put forward for why these changes were necessary was, this kind of idea that the bill as it was from the reference group process, undermined the status of traditional leaders, it undermined the status of these courts. And so to kind of restore the status of these courts, it was necessary to narrow the bill and to remove all of these important acknowledgements of consensual nature affiliation. So actually the power in this process, Marlon, really lay with the Portfolio Committee to make drastic changes that takes the process backwards. And it's very unfortunate that it was the Portfolio Committee that acted in this way, because of course the whole point of the legislative process is that the Portfolio Committees, the committees who are, the lawmakers or part of those committees are supposed to take into account people's opinions, people's views, and to be guided by those responses. And it seems that the Portfolio Committee chose to act in a manner that just ignored people's concerns and that advanced changes that really seem to be moving from support for a traditional leadership lobby.
Thank you very much, Nolundi. Connie, at some stage you were part of the process. How did you lose? Yes. Thank you. How did you lose? Because the question here it's about, because we see here it's a battle between the progressives and those who are not progressive. And you were part of the process. Maybe if you can reflect as to what ended up with you as the progressives or us ending up with this bill, which does not necessarily, which is not progressive. Yes, thank you.
So, even before the process of the reference group, from like the way Nolundi has taken us through the history of this bill from 2008 to 2012 to so we met in parliament from different parts of the country saying we cannot have a bill like this in the new democratic South Africa. People came from all angles with their submission in their own languages, and they said no to this bill. So we were seen as people who are spoilers every time we say no to something that Parliament introduces, and that's why the Deputy Minister John Jeffrey approached us and said to us, let's come with a reference group which is going to represent all angles of the civil society and government, and come up with a bill that will be acceptable, that will be a compromise. And that is why that is how the reference group came into place. We were even hesitant to be in the reference group because if we know that we are not in control of what will be presented at the parliament, and we will be blamed to say we are opposing the bill that we took part in developing. But we went, we said, we argued amongst ourselves and we said, let's just go, because the next thing they will say, we invited you to come and give us your version. We invited you and you didn't come. Remember, civil society is not funded by government. I don't know if there's any civil society that's getting grant from government. We traveled with our time. Nobody's compensating us. They don't even care what petrol we use. We travel to Pretoria almost every week for the reference group. And yet we felt that there was something wrong because there was meeting caucuses, secret caucuses with traditional leaders that excluded us. But in any case, we just went. We just went with the flow, and we reached a compromise, and we felt like this bill is now ready to present to Parliament. Now, so I like it because the Parliament has videos, there's evidence. The first time the Deputy Minister presented this to Parliament, there was a pushback from Matole Motshekga. You understand? One man who's taking his mandate from somebody, I don't know, and saying, you can't do this, you can't do that. We had traditional leaders in the reference group who are very influential in the country. Because, there are traditional leaders who are just traditional leaders. They are not regarded as nothing by Parliament. Because we have traditional leaders who support our stance as well, who are very progressive. So things get spoiled at Parliament. The bill was now edited, and some versions of which are progressive were taken down. So now it means our time investment going to Pretoria was nothing. So we immediately launched the Stop the Bantustan bills. We were stressing each other about resources. How are we cannot represent rural communities, though. Therefore, it means rural communities must be transported to Pretoria to tell the president that, have mercy on us. We cannot have bills like this. This is what we did. But still, this bill is still there, and now it's in cabinet. So the rural people of South Africa in our meetings are saying we have lost confidence in the policy-making processes of South Africa because our participation means nothing. So I mean, really, in the early days of democracy, people used to do things in parliament without anything, and people was happy because they thought it is our government, we voted for it, and it's okay. But now, in the modern days of technology, people can see what's happening in Parliament. So they must stop saying that we are listening to the academic voice, we are listening to the unprogressive white voices, because it is really an insult to us. What does it mean to say to me, or everything that I'm saying, I was told by Nolundi or by some academic person, and what do you take me for? There are people in the rural areas who are watching this show right now. So with the advantage, people can see what is happening. You cannot betray them anymore. So they can see that these people who are our legislatures in provinces who voted for this bill in parliament, if you can ask them, so next time you do this show, please get the legislatures to come and tell us why did they vote for this bill. Some of them don't even know the contents. They were told that the caucus, you must go and vote for this. Because I addressed the legislature of Northwest. I even went to the ANC caucus. And They said to me, we didn't even know what is in this thing. And I told them, guys, this is regressive. It cannot be. But still, they voted for the bill. So who are they thinking they are betraying? They are only betraying themselves because now they cannot betray the people anymore. People are saying we've lost confidence. Even when there's this public hearings now, now with COVID, they have to be on the online. People are saying, why do you even bother to take us and give us data to participate? Because these people will do what they want anyway. The outcome is always disappointing. Even after our efforts to travel to Cape Town, travel to where the public hearings are, still we still get this result. So probably the ANC need to say, who are they accounting to? Whose interest are they representing in Parliament? Because we feel we are not represented. Thank you.
Oh, thank you very much, Connie. Hey, that's a very hard-hitting comment. Now we will go to our next question from David. David says disputes between a community member and their headman are very common in rural communities. While the traditional courts have jurisdiction over disputes between headmen and a community member. Nolundi, kindly respond to that.
So, on a reading of the bill as it stands, the bill requires that where the traditional leader is a party to the dispute, or their family members involved in the dispute, they have to recuse themselves. So the idea is that they wouldn't be able to preside over the dispute, but there's nothing in the bill that would prevent a community member who has a dispute with their traditional leader from taking that to the traditional court. And of course, the idea then would be that the traditional leader has asked somebody else to preside over that matter in their absence. Now, whether or not that's going to result in a fair hearing, whether or not the person who is appointed is going to feel that they would have the authority to make a decision that perhaps goes against the traditional leader, goes against the headman, is a whole other question. But technically, yes, a person should be able to take their traditional leader to the court. The traditional leader wouldn't be able to preside over that matter. They'd have to step aside and somebody else would preside. But whether or not you're going to get a fair balance of power playing out in those forums is a whole other question.
Okay, thank you very much, Nolundi. I would like to follow up on what you've just said. Are there enough mechanisms to ensure that that happens? That when there are such disputes, they are able to recuse themselves?
So at this point, Ganyiso, it's not really clear whether or not there's going to be adequate monitoring of whether these so-called protections actually happen in practice. The bill does provide a role for a justice of the peace, who would be somebody who is legally trained, but really that person only has a role when it comes to assisting a community member to potentially take their case to another forum, a high court or a magistrate's court. And so at this point, there is actually no clear mechanism for fully monitoring whether or not traditional courts actually abide by what's in the bill at this point. So there wouldn't be a way of actually knowing for sure whether the traditional leader did recuse themselves and whether the person that they appointed was somebody who could be objective in that particular circumstance. So, the bill does this thing really of defaulting to relying on a traditional leader doing the right thing rather than putting in place robust protections that would protect people when a traditional leader doesn't do the right thing. So right now, it's basically relying on the grace of the traditional leader being decent enough to say, okay, this is what I'm supposed to do, and actually doing that, which I would argue is not sufficient protection at all.
Okay, thank you very much, Nolundi. We will go to our next question. Is from Sharon. The question is, who presides over the traditional courts? Are they the residents of the community? Are they required to understand the customs? Connie?
According to the Traditional Leadership and Governance Framework Act of 2003, as amended, is that there should be a transitional requirements from tribal authorities to the traditional council. Now, we assume that the traditional council is the one who's supposed to preside, but the presiding officer is the traditional leader, of course. But then the traditional council have to have elections. They are elected and they have to have a composition of 40% from the community, 60% appointed by the royal family or council, and then 30% of the whole structure should be women. And these people, in the courts, the traditional leader herself has to preside. Now, the problem also, especially in Limpopo, in the Northwest, most of the traditional councils have never went to uh, the elections. So we don't know who's going to preside because um, the reason why this act was amended again and again was to extend, because they were given 5 years in 2003. And in 2009, they didn't go for election and there was an extension. And then in that extension, they gave the minister the power, or the minister or the premier, the power to support the tribal authority in processes and logistics to make sure that this happened. Those powers were never used, and then there was an extension. So there was a time, I think 3, 4 years back, Nolundi can remind me, where we were debating the Traditional Leadership and Khoisan bill, which was going to replace this act. And we were saying to them, at the same time, we were discussing the amendment. And we were saying, now what comes first? What's happening? Because this act, the Khoisan Leadership Act, is going to replace all the other traditional laws that are governing traditional institutions. Now, why are we amending it? The reason they were amending it was because these people don't want to go for elections. So probably we are still dealing with tribal authorities, which were composed as according to the Black Authorities Act. And that is the problem, because the Black Authorities Act was designed to exclude women in particular, was designed to exclude Black people from development. It was designed to have our own bogus traditional leaders as opposed to the traditional leaders which were born for that role. So that's the problem. So that question is more relevant to our argument as to who is going to preside and at what cost, because there's another thing of logistics and budget. So they're gonna pass the bill, but who I mean who's the preside the appeals mechanism. They need a competent justice person who can document the law, the proceedings, and say this is what happened, this is what went wrong. If you appeal a case with a mama who my aunt who's often helping in taking minutes at the village, how are they going to be outstanding at the court for you to get justice? So there's so many questions that you can ask, that how practical are you guys gonna do? You're gonna give our faith, our access to justice to an institution that is not competent, which doesn't meet the requirements as according to the constitution. So there's a lot of arguments.
Thank you very much. Maybe before we wrap up, I would like to ask the issue of like the meeting the composition requirements for traditional councils, and also the issue of elections has been raised for a number of years. Why is it not happening? What is stopping it? And Nolundi?
So Connie is absolutely right, Nganyi. So the one part is that they do keep amending the timelines to allow these councils to finally abide by the requirements in the law. But it is, both partly, as Connie points out, a disregard on the part of the councils to this requirement. But in addition to that, it seems that there are capacity issues with the IEC and their ability to support the running of these elections. And so really, it would seem that nobody is monitoring this. And this is the realm, this is the point, as Connie was making earlier, this is the realm of COCTA, right? This should be the Cooperative Governance and Traditional Affairs Department, who is keeping an eye on this and making sure that these elections are happening as they are required to. But there just is no follow-up, it would seem. And rather than, saying to traditional councils that haven't complied, this is the deadline, either you meet the deadline or there are consequences, the state just keeps extending and extending and extending.
Thank you very much, Nolundi. It is clear that there are delays or unwillingness to meet the composition requirements and also to hold elections. Maybe, Connie, just to ask you, like on the action part, what needs to be done? Because it seems like if nothing is done, this will continue for a number of years, whereas the very same traditional councils that are given these tasks of administering justice and all that will be around. So, Connie, could you kindly maybe suggest like what needs to happen in order to make sure that they hold elections, they also meet these composition requirements?
Mm. So what needs to happen? I think this is, I'll give a multi-layered answer, because all of us, whether you are in government, whether you are in the civil society, and the community agency itself has to show up. So what needs to happen? I mean, we currently we have instructed our lawyers to take this thing and give us legal advice, and if it comes to a push, we must take it to court with together with the Traditional and Khoisan Leadership Act, which is in the process of going to court and which is coming into effect today. Really, we're debating this, and there's a traditional this Khoisan bill is coming into effect today. So it is a court. We give ourselves, but we shouldn't give up our own agency. And for the communities who are listening today, we need to have a defiance campaign. We need to defy these guys. If they call you resist, you know, we must resist. We come with a resistance campaign. We must defy them, and even where we like them, because the governance in rural areas is under traditional authorities, and if traditional authorities are not going to listen to us, they want to be dictated by a certain act from parliament as to how they govern their own territory, then we're going to defy them, because we know that they are taking instructions from parliament, they're getting salaries. People must show their own agency. We cannot always blame lawyers for not taking our cases to court, because once the government the court has ruled, we've got so many cases that are similar that we won the cases. But what is happening on the ground? Business still goes on as usual, and that is why the people's agency, people must mobilize, people must fight this thing. This bill must be scrapped. To parliament, we're saying to them, they must scrap this bill. If they want to still see them enjoying our votes and whatever, they must scrap this bill. I've asked the question earlier, who are they accounting to? Whose mandate are they representing in parliament? If it is our mandate, then they shouldn't have voted for this bill. So we are not going to sit down and during COVID, everybody was in lockdown and people are making decisions in parliament and pushing bills in. We are not going to sit down, because this is our fate. If you take my grandmother's land and telling me that I must come to some court for it to tell me that I cannot plant there because there's a mine coming to operate. So you go home, you find your livestock locked in the kraal because there is a prospecting happening in the grazing camp, and livestock is terrorized. Then it's war, guys. We cannot avoid it. If it's war, let's face it. So this is my feeling as Connie, but this I hope our communities are listening. No Messiah is gonna come from Cape Town to save you. We need to support your initiative as a community. You are already resisting. So when Tina, we are coming to reinforce what is already there. We will never give up. We'll never give up our agency. We'll fight. We defeated apartheid. We will defeat this government if it still treats us the government. I want to quote Nelson Mandela when he said, if you feel like the ANC government is treating you like the apartheid government, do unto them as you did to apartheid government. And this is what we will do. Thanks.
Okay, thanks, Connie. Nolundi, any closing remarks before we end the webinar?
Just to say, Ngangi, so you know that I think Ascani's statement is incredibly powerful. And for people who don't, live in rural communities, who wonder why these issues matter, why are these bills something that people should care about? To say that, ultimately, I think these bills are a threat to the idea of one South African citizenship. We already know the levels of inequality across the country in a range of different, spaces, economic inequalities, access to resource inequalities. And if we are going to submit and allow these laws to pass, we're effectively allowing and endorsing an inequality of citizenship for some people in our country to be, subjected to a different system of law, to be classed as secondary citizens. And effectively, we would be betraying this idea that this is one South Africa where everybody should have an equal experience of what it is to be a citizen. And so, for that, I would say that people who live in other parts of the country too should be worried about these laws and should be interested in what's happening.
Thank you very much, Nolundi and Constance, and also to our audience. Please do join us again next week, same time, for our webinar, which will be looking at the implications of COVID-19 on the food systems in Southern Africa. We are going to be sending out adverts. Please do join us again next week. Thank you very much and goodbye.